All right, you're live.
Thank you. Welcome, everybody, to the House General and Housing Committee. And today is Thursday, February 20th, 2025. And our first round of witnesses starts with Peter Gill, Executive Director of the Land Use Board. Peter, would you come and have a seat? And Peter, you know the members of the committee. However, with Peter are two new members of the Land Use Review Board. They have arranged to be here without constituting a quorum. Just two of them. I don't think you've met the committee, so I'm going to have the committee introduce itself to you. Elizabeth, you want to start?
Oh, sure. Hi, I'm Representative Elizabeth Burrows, and I represent Windsor 1, which is Heartland, West Windsor, and Windsor.
And I'm Gail Pezzo, and I represent District 20 in Colchester.
And Gail is a mobile home expert.
Oh, I am?
You are. You are, and you're going to be having even more of one.
Okay.
I'm Debbie Dolkin, and I represent St. Johnsbury, Concord, and Kirby.
I'm Tom Charlton. I represent Athens, Chester, Grafton, and Linden.
Joe Parsons, Newbury, Topsom, and Groton.
Leonora Dodge, Essex Town, City of Essex Junction.
Good morning, I'm Ashley Bartley, Fairfax in Georgia.
And I'm Mark Mahaly, and I represent Calais, Plainfield, and Marshfield, and welcome. So I'll tell you what, Peter, would you introduce yourself? And then I'm going
One
to.
more. Sir.
Oh, Saudia, would you please introduce yourself?
Good morning. I'm Representative Saudia Lamont, the Royal Washington District. That's Morristown, Elmore, Worcester, Woodbury, and a small part of Stowe.
Saudia, thank you. My apologies for overlooking your large name is right there. So, and we hear you clearly, by the way. Do you hear us clearly?
Yeah.
Saudia?
Yes.
Good. Okay. So, Peter, if you would introduce yourself, and I would ask that the two members also introduce themselves.
Great. Pete Gill, Executive Director for the comes off the tongue easily. The Land Use Review Board, as of Act 181, the name change from the Natural Resources Board to Land Use Review Board. Pleasure to be here. Thank you. Turn it over.
My name is Brooke Dingle-Dean. I've been a lawyer in Vermont for 30 years, practicing environmental and land use law, and I'm honored to have been selected to be on the Land Use Review Board as a member. And I do live in Randolph, so Central Vermont is my home, but I also have practiced all the way to the Canadian border and Massachusetts border.
I'm Janet Hurley, the new chair of the Land Use Review Board, and I live in Bennington County, where I worked in regional and municipal planning before joining the board.
Great. So, Peter, do you have testimony that you prepared that you want to give, or are we entirely using?
We don't have specific testimony, but although I'll just say that we were informed that you all were interested in the appeal study that is part of Act 181 and learning more about that and understanding kind of the timelines for that. The board has, in part because of the open meeting law and making sure that we're in conformance with that, have kind of siloed some of the work that is to be done under Act 181, and Brooke is our expert on the appeals, or the lead on appeals on that study, and so she can talk a little bit more about kind of the work that she's done to date. As you know, they were seated on January 27th, so they're still getting accustomed to the new role and everything. But with that, we're getting right to work. So
I do think it might be good for you to talk to us a little bit about the study, Brooke, and how you see it going.
Sure, I'd be happy to. I'm sorry I didn't have an opportunity to email you folks the handout that I've passed along, but we will make sure to send that to you digitally. It's just an outline in terms of the report and the specific issues that we need to grapple with. So on page 1 and part of 2, I just copied the legislative charge from Act 181. And then in the second section on page 2, I kind of isolated out the reporting requirements so that we can look at them individually and plan for each of those tasks. What I have done in the beginning was, I don't want to reinvent the wheel. I know that there has been quite a bit of study and efforts to determine whether or not to go initially to the environmental court, then the environmental division, as opposed to the environmental board. As a baby lawyer, I practiced before the environmental board. So, but this is not that. This is a new board with the diversity of expertise that has been created to make sure that we have really the expertise on the board to look at land use permitting in a way that makes sure that we cover all the bases of Act 250. We not only have an ex-district coordinator, she is a licensed engineer. We have forestry and wildlife expertise. We have amazing municipal and regional planners who have also been involved in the administration of zoning, which is very important here. This isn't just about Act 250. It is about determining whether or not we can find a quicker way through the appeals process. And can we consolidate the appeals from zoning, the A&R appeals, which tend to be more piecemeal on specific issues, and then, of course, the Act 250. Now, how do we, we have to look at, shall that stay with the environmental division, or should it come to the land use review board?
You know, I want to back up just a little because not all of us have quite the background that you do. So right now, before things change, would you tell us what appeals go to where?
Sure. So if I want a zoning permit at a town, I go through that process. It would go through the development review board, or most towns call the entity that, if they have zoning. And that appeal by either the applicant, if they were denied or they received conditions that they were not happy with, or there were other parties such as neighbors who qualified for standing, that decision of the development review board would be appealed to the environmental division. And then it would go through the litigation.
The environmental division, excuse me for interrupting,
is
what we think of as the environmental court.
Right. We still refer to it often as the environmental court. It is part of the Superior Court. We have criminal, civil, probate, and then we have the environmental division. And now we have 2 judges. We've had 2 judges for some time. We just had a replacement. Unfortunately, Judge Durkin has passed away recently. And he was 19 years on the judiciary and was a lovely person and wonderful judge. So we have Judge Walsh and now Judge McLean. So we have very learned and capable folks in that position. We've heard a lot about how it becomes too litigation based, too expensive, too long involved. There's discovery where documents go back and forth, and even depositions are taken, which is curious because it's a de novo hearing. You get a new chance at presenting your application, or the opponents get to say they need to come and do their dog and pony show here in front of judges because we don't agree with the decision. So it's the same process with Act 250, but the entities at Act 250 that make the preliminary decisions about permitting are the district commission, and they have a coordinator that is the administrative person who helps to administer it. And through that process, it's more criteria. There are many more issues that are looked at, like compliance with the town plan and criterion 10, and many criteria that relate to A&R, like wetlands and stormwater, and so that it's much more comprehensive. And that's what it was designed for, because it was supposed to be capturing the big projects. Or in towns that didn't have zoning, we call them 1-acre towns. if you're doing a commercial development and the piece of land is more than 1 acre, then you're in Act 250 permitting. In places that have the permitting of zoning and subdivision regulations, those folks, those towns are called 10-acre towns. And only if the commercial development is more than 10 acres of land that's being developed, or the parcel of land, then that would go to Act 250.
Brooke, just one question. If I'm in a zone which allows, let's say, residential use as of right. So, or I'm in a town with no zoning. So all I need is a building permit. Is the building permit appealable to the court?
The building permit would issue from typically the zoning administrator. And
There's
then,
one, yes.
right, and then that would be appealed to the DRB.
Yeah.
typically.
There is one, yes,
Right, and then that decision could be appealed to the court.
to the court, a
Right.
building permit.
Well, so it's a
as-
zoning permit.
Yeah, you had new zone.
Yeah, so a building permit is something that commercial buildings need from the state. So, and a few of our bigger municipalities have building code, and the building code is different from zoning.
So do you mean,
So
there are
zoning
towns-
permits are appealable to,
right, but if a town doesn't have zoning,
there is no.
then you don't, then
There's no
there's no
permit.
permit.
Yeah.
They mean without zoning, there's no building permit. You just.
There's no zoning permit. If it's a commercial building, it still
But
needs.
we're talking
a building
residential.
permit.
If it's
Oh,
a,
residential, correct,
there's,
right.
in other words, if a town doesn't have zoning, it probably doesn't have anything that would require a building permit.
Right,
So you just do it.
for residential, correct.
Right,
Yeah.
okay, thank you.
So when we get to the environmental division, I've heard a lot about, consolidation. And they don't use that term when they, for example, I might have a client who wants to do zoning first, make sure that they get the zoning permit. Once they get that, then they'll do Act 250. Sometimes they'll do them simultaneously. And if they hit the court, doesn't have to be the same day, but say the zoning's in a preliminary stage and then Act 250 comes up, they do coordinate the appeals, but it's not called consolidation. Now, looking at the statistics, I did on page 3, I inserted just one snapshot of the most recent Vermont Judiciary Statistical Summary from 2024, just to give you a view of where the volume of cases are coming from that go to the environmental division, just so that we have some context and understanding of what kind of volume that we're talking about. And looking down the incoming, say, let's just look at that for Act 250 and A&R de novo appeals. They had 17 that year. They have enforcement and civil citations. Those pertain to when you violate permitting conditions or don't get a permit that is needed. Not sure exactly what miscellaneous covers. But then we get to the municipal de novo appeal. And that is what we're talking about when we talk about a zoning permit that goes up to the environmental division. And you can see that's 53 incoming cases. So it is considerably larger than the Act 250 cases that are appealed.
Is that, do you have any idea how many of those are appeals by the project proponent of a denial versus appeals by a neighbor that doesn't like the approval?
Not yet. I have not had the opportunity to dig into the statistics yet, but we will certainly look at that because that is very important. The notion of frivolous appeals and preserving or providing a conduit through which nefarious, appeals can happen, just to be obstructionist. It's anecdotal, but it does exist. I have experienced it more than once or twice on occasion.
Yeah, I think that breaking that down into project proponents versus project opponents would be most useful.
And we do have statistics in terms of, and I just don't have them in this handout, but it's a very small percentage after appeal that are actually ever denied. I think it's like 0.2%, if I'm correct.
That
Or-
was,
0.2% is from the district commissions, what their denial rate is 0.2. Not sure what it is on the appeal level, could be similar, but.
Gotcha. But we are talking about a smaller segment. Now, that's not to say these are not the cases that take time and are being, creating obstacles to getting through this process quickly. Let me just point out, on the municipal enforcement, that's again, the enforcement is when they are perhaps doing something wrong about their conditions or they don't have a permit. The
the
next,
zoning permit.
a zoning permit, right?
We have a question over here.
Is this primarily commercial or residential or mixed?
It's mixed.
It's what?
It's mixed. It's not just commercial. It would be
Okay.
housing or any of the permitting. But I just wanted to point out the last line item here is on the record appeal, and there were 8 of them. And there were 2 kinds of appeals from zoning. The larger or more resourced municipalities will do an on the record appeal, meaning they have to record it, the evidence is put in and preserved, and if it goes up on appeal, it goes to the environmental division, and what they decide is, was there a mistake made? And it has to be a pretty big mistake, okay? And you don't get to put in new evidence, you don't get another bite at the apple. It's a review of the decision that was made, as opposed to the majority of towns are de novo, and that means,
Besides which,
pardon
The
me?
town themselves.
Yeah, they
but I
decide.
assume there has to be a record for
There
the.
does. It's pretty strict, and that's why there are only a few towns that have the capacity really to meet those.
I think that, by the way, when you think about your report, just my personal opinion, is that it would really be worth looking into that issue a little more deeply. We had introduced the bill to create an environmental court, what do we call it, a housing court.
Mhm.
And one of the things that's really clear is, to me, is that as long as you have de novo review, you're gonna have a long process.
Yeah.
It can't happen quickly. And so I wonder whether we could create a situation where we have a shorter, whether we have, instead of having the town decide, that a proponent could decide, I'm gonna pay to have a court reporter in here. And that way I will know that it's on the record.
And there are maybe other mechanisms if, to compare a de novo versus an on the record. I see the biggest problem with de novo review with the environmental division is that it's, become real litigation,
Mhm.
normal litigation. Whereas I can remember the first cases that I had in the environmental court, nobody had discovery. Nobody, you just showed up and had a hearing. And there wasn't depositions. I mean, you just did your presentation below. Now you're going to give it to a different audience, and stripping away all of that, it's sort of been a runaway train in a sense that now there's no difference between regular civil litigation and environmental division at times. Now, the environmental division has the authority to allow or not discovery, but I think it's just become sort of the norm that it's.
So what you're saying is one approach might be to encourage on the record decision making, but another might be to create specific procedures that are much more abbreviated and don't allow certain things.
And have time deadlines, not
Right.
just we
Do you
recommend.
see yourself getting into that in your report?
I think so, because I think I have already been engaging with stakeholders and trying to really, hear preliminarily to try to identify what are the issues and what are the topics that we need to look at to figure out, how do we make this all faster? And, A&R permitting is really important that Billy Coster and us sit together and figure that part of it out. Because that, I think, would be more suitable for consolidation than, not to say that the zoning case and the Act 250 case should not be consolidated. They should, but the problem or the perceived problem is that zoning has, character of the area and, different standards than the Act 250-10 criteria. But in my opinion, from every time that I have done a coordinated case, it makes all the sense in the world. Because even though you have two sets of legal standards that have to be analyzed, the evidence is the evidence. And there's no reason to go through that process two times in front of two different appeal boards. So I think not only will core consolidation help, but it will also give the developers they will be comforted by the fact that everything's going to be heard together, or they're able to do that if they want to. I don't think it should be required, but it really will, I believe, speed things up if you create that one-stop shopping. Here is our project. Okay, figure out, do we pass muster with A&R? Or did A&R make the right decision if it's on the record? And then the same thing for zoning. Did the zoning board apply the law properly? And then again, for the Act 250, it's the same process.
One of the things you might want to look at is, I think the report would be most useful to us if it contained a proposal, if it needed an appropriation because you needed more support than you have. It would be great. Might even be worth a week in the deadline. If there were language, proposed language to implement and a proposed appropriation.
Understood.
Yes, Leonora.
Thank you. Just briefly, do you see any need or desire for there to be kind of a split in the decision-making process when you're considering commercial versus residential building? Or is that too complicated because sometimes you're going to have a mixed use or as you will?
Sometimes you will, but I think of it more as, okay, so there are different categories in Act 250. If you need just a little change to something that doesn't impact, the conditions or is not significant in any way, you might just need some hours changed of operation or something. That can be done through an administrative amendment. And it's like the zoning administrator and zoning just, giving a building permit or something. It's not appealable, up to the courts and all that. So then when they look at the other more significant projects, often what they will do is say, this is a minor application because the staff does not perceive that there will be significant impacts on the Act 250 criteria. And what they will do is they will send out a proposed permit for comment and for people to say, wait a minute, I am impacted. I can establish standing because I have a particularized interest, that standard under Act 250 for establishing that you get to be an interested party. Those, if an interested party comes in and says, I want a hearing and can demonstrate, hey, the stormwater plan is not going to work and my property is going to be flooded by this project, then Act 250 has to make a decision whether or not they're going to have a hearing. Did this person, make the showing that they should have a say in this? And if they do and it's a hearing, it sort of automatically becomes like a major permit. And in my mind, those have already been determined not to be that huge a deal, to try to use the vernacular. It's like, okay, it's confined, it's finite, it's not some huge Costco project or something like that. And if in that context, you had a very abbreviated process there, and then, okay, the few minor or the few ones that are truly major that are determined to be major right off the bat, those are the ones where you allow more process. That is one way that I've sort of conceptualized trying to figure out how, it's not necessarily the topic of the project, but it's how significant is it and how much potential is there for any harm to whatever the criteria might be.
I guess the only reason I ask about, having some kind of bifurcation is just because we are so desperately trying, housing is just so foundational for our whole economy and our health and, public health indicators and all of that. And so, I think a lot of us have been hearing that simplifying process to build housing is
And
desirable.
one of the things that's happening is these interim housing exemptions are in place. And when
Right.
we get the new framework, the new jurisdictional framework in place, a lot of housing projects will be exempt from the permit.
And I do see that you have under C here, you are going to look into prioritize and expediting housing appeals.
Absolutely.
Yeah.
And if that is, you know, we will examine by topic. If it's housing, let's get it through housing process that is much quicker and folks can rely on it and know that it's going to be applied. They will get through it quickly because they're looking for certainty. That's what folks who are investing in these projects, they want to know it's going to be, you know, X time period because time is money. So absolutely, we will look at that because we know that's the priority. But one of the pieces of information that I think we have to discern is figuring out, you know, how many of these appeals are about housing. And because that's important to see kind of, it's not even anecdotally, it's going from the data to try to understand what's behind it.
And we also have to understand that
You
there
just continue.
are already changes in the law that limit appeals on housing, like the character of the area is no longer available as an appeal criteria.
And that has been, let me
Yeah.
just, I don't want to interrupt you, but just to give you a little bit of context, that character of the area is sort of the analogous amorphous standard that's similar in Act 250 to Criterion 8 aesthetics. You know, it's very subjective.
Yeah.
And so that is where you see a lot of these cases get tripped up. And there's a lot of opinions about the character of the area and what changes it or shouldn't change it and all of that.
I guess I was just gonna say, I know that a lot of us really like to work from, you know, the perspective of data. But we don't know all of the projects that die in infancy and the very thought because, so they never went through any kind of process just because people didn't bother because they knew it was gonna be
I think
too
that's
hard. And so,
important. That's an important piece to our stakeholder group is we can get at some of those probably, depending on, you know, what, who's participating in that stakeholder group. So I don't know if you want to talk about that, Brooke.
Yeah. So there are lots of lists that I've been looking at from the past studies. And we just have a wonderful brain trust here in Vermont of folks that, you know, were coordinators for many, many years. The staff that we still can talk with and are still very engaged in environmental issues to understand how things really operated with the board. Just to get that sense of the internal operation of it. Because one of the big issues that we also have to deal with is conflict of interest. You know, if we are in charge of the district commissions that are making this decision, and then our lawyers might help, you know, write the opinion or something, and then we're the appellate board. We have to figure out, now, wait a minute, we are like sitting in judgment of our own decision in a sense, or
we made the right decision.
Welcome to the Public Utilities Commission. I mean, this is life in the big leagues. Come on, you can do it. But one of the things I'd like to just elaborate a little as a stakeholder, I guess we're sort of stakeholders on what Leonora was just saying. I too am a fan of data, and very often these anecdotal stories, they're tied together like little things on a necklace to create a picture that isn't true. That can happen. I've also become aware of a counter process to that. Development in Vermont, residential development in Vermont is intrinsically risky. We've heard testimony repeatedly that outside of Chittenden County, it's very difficult to make a housing development pencil, period. Because the prices that people are able to pay are not sufficient to support what it costs to build, given materials, even without tariffs. So a lot of builders are kind of shaking their head, trying to figure out whether they can do this or not. And in the back of their heads, in fact, I wouldn't even say the back, right in the front of their heads are these stories. And they may be isolated stories, but they're famous. They're big projects that had a lot of community support and a lot of impetus that got held up for 2 years in a process that included the Supreme Court in one case twice. And what that does is it discourages, I think it's part of this culture and atmosphere. I mean, people keep talking about changing the culture at the local level, but we also have to change the culture and the perception in the development community. And they're looking to you, I think, and this kind of a study and us to try to do that in some way. That's part of it. It's just a reality.
And I think the coordination or consolidation with A&R is super important for the developers, because so often they feel like, well, wait a minute, I got a wetlands permit and now I have to prove to Act 250 that I'm okay. And it's only a rebuttable presumption, and somebody comes in with an expert and tries to argue about it. That duplicative, whether it's a perception or not, or it's reality, that I think is very discouraging. It's, you know, you feel like you're going back and forth to A&R when you're in the Act 250 process, and, you know, they make comments and it's all important, but there must be a way to make that happen more quickly as one process. You know, for example, if you get an air pollution permit, you should be able to pass muster on criterion 1 air pollution. And why is there only a rebuttable presumption if the experts at our A&R division, air division, have determined this is only what you're allowed to emit, and make sure you got scrubbers on your apparatus and all that kind of thing.
I'm asking you questions because we don't have too much longer, and I just want to make sure we get a few things out. I don't know, Peter, if you want to comment, or if you want to comment. Is this report, is it doable in November of this year?
Honestly, it's the difficulty we have in operating as a board right now. Sure, I have 30 years experience in this, but I can sit with Janet and talk about things and, you know, what stakeholders should we have? I don't feel like that's, you know, I have a whole list of people. And we're trying to make sure that we follow, obviously, the statutory parties have to be, or stakeholders have to be engaged. But being able to operate as board, we were designed with all these different expertise, and having everybody be able to help me at, you know, work through this plan is critical. And you know, having to do that in open meeting, it has nothing to do with trying to do things in secret. It's enormous in terms of the resources and personnel that are required, because now we have to be on YouTube if there are more than 3 of us in the room. If we could get relief from that so that we could operate in our, you know, 40 hours a week. This isn't a board that shows up once a month and, you know, meets like a select board or something like that. That would be critical to being able to not just comply with the deadline, but to do a darn good job. This is so important. I feel such a
You're talking amongst
responsibility.
yourselves.
Right,
Do you have is a committee subject to the open meeting Act?
yes,
Okay. Even if it's 2.
Yes.
yes, if it's a,
If
yes,
it's a
because
formal
we're
committee,
a non-advisory board, and if 2 members of the non-advisory board are a committee, they aren't considered advisory.
Right.
They're considered non-advisory
Right.
because they are members of the board, so.
Okay. Have you included in here any statement of what exactly you would like to be able to do without the open meeting act?
No, but Pete, you have presented. some
Well, we're-
information, or Janet.
We've talked with government ops, Senate government ops. We've talked with other committees of jurisdiction for Act 181 in particular for that. And the governor included an exemption of the open meeting law, which we're not really looking for an exemption. we're looking for a way that we can work together as a board during the week outside of our regular open meetings. We would be working together, and when we came to a point where we needed to make a decision as a board, we would do that in the open meeting. But there are things like coordinating, the different stakeholder groups. One of the issues is you don't want to overburden, a particular stakeholder by asking them to be engaged with each of the five of us on each of the five different, major tasks that we're undertaking. And so simple coordinating work like that, we would have to think about how we would have to choreograph everything that we do together 48 hours in advance and post the agenda and have somebody set that meeting up and, record it and be sitting somewhere because we need a physical space. So how we can work together efficiently on this is hampered by that, which is not to say that we're not going to be able to do it. And we can have one-on-one conversations on a regular basis, and that might be what we have to do. But it's not efficient.
Yeah, I mean, I'm heading this, but I have no experience with stakeholder meetings and, public engagement. So, I have to call Alex Weinhagen, or I have to call Sarah, or I have to call Janet. And the amount of time that is consumed by that, just so that I can get somebody to help me with that.
Thank you.
The only other thing I'll say is all we're asking really is to be treated like the PUC. I mean, we are similar and,
Although they are a quasi judicial board.
well, we are as well, in terms of, well, not quasi judicial,
We have two appeal rights to the board that potentially would be
What are they?
quasi judicial, but so there's fee waiver appeals and one other one that I'm blanking on at the moment, but it's energy compliance determination
Okay.
within plans. So they're minor at the moment. They oversee a quasi judicial process, obviously,
sure,
in
obviously,
district
yeah.
commissions. But in terms of their actual work, it is more policy based at the moment. But I think the biggest thing is as Janet was mentioning, it's a hamper in terms of their ability to work collaboratively. And I think this legislature put together Act 181 and wisely required certain level of expertise in the board members and created a professional board that was fully engaged in this process. And as executive director, I want to make sure that they are fully engaged and can be fully engaged in a way that is both, public and open process wise, but also efficient use of resources.
Finally, I have one question, which Peter, I don't know which of you wants to answer. Right now, under Act 250 and only Act 250, anybody who wants to appeal an Act 250 permit has to show that they're an aggrieved party. Has that standard worked for you?
I think it's worked fairly well. I'll start and anybody else can join in. But I think it's worked fairly well. And beyond that, it's a standard that has been in Act 250 for a very long time. And that consistency of knowing how that plays out in the case law that stands behind it gives people a lot of consistency in how that plays out.
I'd agree. I think it's a better standard than what we have in zoning.
Anyone can appeal zoning at the moment, whether they're in a butter or whether they're
No.
agreed or not.
Well, in the immediate neighborhood, or we've gone from the 10 to the
20, right.
Yeah, right. I think if you guys have any last thing, does any member of the committee want to ask a question? No, you're just fooling your pen.
I would say like that particularized interest.
I don't know if this is germane to right now or not. If it's not, then I can come back to it. I'm looking at the word enforcement. I'm not a lawyer, so you'll have to help me translate. In a situation where an extraction operation acquires an Act 250 permit, and there are certain criteria they have to meet and conditions and so on. 10 years down the road, they're not meeting those criterion, whose burden is it to establish if they're in violation, that it's affecting adjoining landowners? Who brings that? Does the state enforce? Does the state
It's us.
investigate?
It's the land use review board and probably at the district. Well, we have
Yes.
2 enforcement officers for the state and they would
Okay.
take that on.
Even if it's an A&R?
No.
No, yeah,
Just
so
just
we,
the Act 250 permit.
and we have a
Okay.
memorandum of understanding with the Agency of Natural Resources because there are oftentimes underlying permits from the agency that are incorporated into existing
Permitting.
Act 250 permits.
But does 21 A&R and NRB enforcement that you have here, is the word enforcement modify both of those initials? In other words, are there A&R permits that are appealed by, let's say, the project proponent that doesn't like the A&R permit? Or an A&R permit that's challenged by citizens? Or is that line all enforcement? Or is it both?
I believe it's all enforcement. Now, neighbors might be involved by triggering with a complaint. And, but they, while they may be aware of it, they're not a party to the enforcement action.
What happens if I am a developer and I get an A&R imposes a permit and I disagree with it? Who do I go to? I sue in the courts,
Those go to the environmental
the
division.
environmental division. But those, are they counted? Where are they counted in this table?
Oh, the permitting on that?
Yeah.
The top line.
It would be, yeah, they put A&R and Act 250 on that top line. They put them
Okay,
together.
de novo appeals, great, thank you.
Yeah,
All
so I
right.
can break that out and get more information.
Any questions of,
This is totally superfluous, but what acronym do you use for yourselves? Hopefully.
LURB, that's what it is in the statute.
Do you call yourselves LURB?
That's what it is in the statute.
Just wondering.
LURB. I don't,
If it had been LURD, they could have been lurid.
it's your fault.
I take responsibility. I needed the chuckle.
people think that all the time, but they rarely actually say it.
Yeah.
On the record. Okay, it's very true. Thank you so much.
Most well, I just wanted to say one thing, going back to the enforcement question. As of last year, we had one enforcement matter from the Land Use Review Board that had an appeal. And that's pretty rare in the grand scheme of our permitting.
Yeah, there is a settlement avenue for enforcement actions, and I've been through many of them representing folks that, you know, were enforced against. And it's definitely the way to go for someone if they are in violation. And there is, you know, a reduced fine if they're willing to, you know, settle on it. So there's a real off ramp for folks to just getting compliance, but, you know, there are fines that they would have to pay, but lesser if they're not going to go through the whole court process.
I
Great.
think we got testimony from somebody who was at the, having to build the sidewalk, or that was at zoning level.
Yeah,
That was,
zoning.
that's really.
Well, thank you very much. I really appreciate your taking time away from this new and demanding obligation. And congratulations
Thank
on
you.
your appointments. And thank you very much.
Thank you for having us.
Appreciate the time.
Say to the committee as well, we've got our Land Use Review Board annual report from last year. It's up on our website as well as on our legislature's website.
And you're gonna send us an electronic copies of it?
Sure.
Thank you.
Yeah, and
Thank
could
you
you
very
send us an electronic copy direct, you send it to our committee assistant,
Yes.
both this and your annual report.
Happy to.
Okay,
So nice to see you
guys.
Nice to meet you all. Yeah.
Our next witness is Sarah Truckle. Sarah, are you online yet? There you are. You have to unmute yourself. Although I know you, I don't think members of the committee know you. And so why don't we have the committee introduce themselves to you? Sarah, by the way, Sarah is, just so the committee will go through the introductions. I asked the Vermont State Colleges to make a proposal concerning training of more people in the trades, because we've heard so much about it. And Sarah, I believe, is in charge, or ultimately in charge of that program. And they made a proposal, and that's why she's here. So why don't you introduce yourselves to her?
Great. Good morning. Ashley Bartley from Fairfax in Georgia.
Good morning, Leonora Dodge from Essex Town and the City of Essex Junction.
Joe Parsons, Topsom, Groton, and Newbury.
I'm Charlton, Athens, Chester, Grafton, and Linden.
Debbie Dolgan from St. Johnsbury, Concord, and Kirby. Good morning, Gail Pezzo, District 20, Colchester.
Good morning, I'm Elizabeth Burrows. I represent Windsor 1, which is Heartland, West Windsor, and Windsor.
And I'm Mark Mahali, and I represent Plainfield, Marshfield, and Calais. Would you introduce, oh, yes.
I think
Oh, and we have Saudia Lamont. Saudia, are you there?
I am Lamoille, Washington District, Saudi Lamont. Thank you. Nice to meet you.
Nice to meet you all.
So you want to introduce yourself and give us your testimony?
Absolutely. Good morning. My name is Sarah Truckle. I am the Vice President of Business Operations for Vermont State University. Thank you for the opportunity to speak on the importance of HVAC apprenticeships. Specifically, I just want to make sure everyone knows what HVAC is. So it's heating, ventilation, and air conditioning. And I have seen firsthand the significance of the apprenticeship programs have had both on individuals and Vermont's workforce. Vermont State University's existing apprenticeship models in plumbing and electrical have been highly successful working with employers throughout the state, as well as currently enrolling 898 students, which is our highest to date. HVAC apprenticeships are critical pathways for individuals to develop both practical skills and the technical knowledge needed to thrive in an expanding and critical workforce field. Through these programs, apprentices gain valuable hands-on experience working along with seasoned professionals who mentor them and provide real-world problem-solving opportunities and ensure that they understand the distinctions of HVAC systems both at the residential, commercial, and industrial settings. Benefits for the apprentice is the model offers a unique opportunity to earn while they learn. By combining classroom education with on-the-job training, apprentices can see a direct application of their studies in real-world scenarios. This method not only builds confidence, but it also equips them with a diverse set of highly regarded skills by the employers. For employers, it is an excellent way to ensure a steady pipeline of skilled and reliable workers. By investing in the apprenticeship process, employers can tailor the training to meet their specific needs and ensure that the apprentices are prepared to handle the challenges from the job on day one. Additionally, apprentices often foster loyalty and reduce turnover within their fields, and they stay with the company that helped train them. We have existing employer partnerships that are already in this field, particularly with our plumbing and electrical apprenticeships. And this is a pathway that they are looking for to support and diversify their workforce. The HVAC industry is evolving rapidly with the advancement in technology and sustainability becoming more and more central. Notably, we've seen this in the rise of heat pump use in Vermont. The U.S. Bureau of Labor Statistics projects a 9% increase in HVAC jobs in the next 10 years with an average starting salary of $56,000. There is growing demand for workers who not only understand traditional HVAC systems, but are also well-versed in the emerging technologies such as energy efficiency systems and smart home integration. Apprentices provide a sustainable way of keeping the workforce adaptable and competitive in a changing landscape. The proposal that we are making really focuses on propane, oil, and refrigeration training. Particularly, students would have the propane certification of 152 instructional hours, the Nora Bronze Basic Oil Heat Technical Training Program, which would ultimately allow them to sit the Nora Bronze test and receive a certificate upon completion and passage of the exam, and the Air Conditioning and Refrigeration Training Program, which would allow them to sit the EPA 608 exam, which is required for working on refrigeration in Vermont. The program can be done within 12 months with 2,000 hours of on-the-job training, resulting in apprentices being fully trained within 1 year if they pass their certifications. So it's just a bit of an overview, and I'm certainly happy to answer any questions.
Questions from the committee? I have some questions, but committee members, Tom, this is your area now. Do you have?
Question. How fast can you bring a program like this online?
Within a year. We
Okay.
already have employers that we're working with who have expanded into HVAC. So we feel really confident in being able to just expand this within our existing employer network and then bring it to other employers as well.
As I remember, I don't have it in front of me, Sarah, but as I remember, you're asking for some 300,000 or so. What is it?
100,000, and we could stand it up within 1 year.
How much is it?
100,000.
Oh, that's different. When I don't have it in front of me, but I saw 2 columns on the proposal. One column was for an IT thing, which would not be in this committee. And one column was for us. Do you have that, Tom?
I don't think I do.
Okay,
Unless-
I thought it added up to like a couple, like 200 and some thousand. Do you have that? Is that different?
That's different from, I think, Vermont State University's. I'm happy to clarify if there are
Yeah,
other
let's
coming from the
definitely clarify that, Sarah. I will send you immediately when I can. I will send you what I have when I can fish it out of my computer. I don't know where it is. I guess a couple of questions. One is, could you kind of tell us in plain English how this would work? You know, if I'm an employer, what do I do? If I'm the student, where do I spend my time? Who pays, et cetera?
Sure. So the way the apprenticeship models work is employers really recruit actively new apprentices. So they come and they work directly for the employer. So that's the 2,000 hours of on-the-job training. The employer then sponsors the tuition associated with these courses, which is covers the certifications, the exams, and they do their 2,000 hours of training, which is 1 year of work, while they also take these classes typically for electrical and plumbing at night. So they're online, they can do them at their own pace, and they're able to go to work during the day, learn at night, or per their schedule as they allow. They're working directly with an employer. So that's really where we see the reduced turnover, the attrition that we've seen in other industries isn't there because they go in through the employer. So the employer will advertise these as apprenticeship positions. They then come into the employer as a worker, and they're training on the job with the supplemental academic opportunity through Vermont State University.
So how much is it cost? If I'm an employer and I want to do this, what order of magnitude do I pay VSC?
So we did a preliminary what we thought the cost of these programs would be. So I'm happy to give an overview of what that is, recognizing that ultimately we would need to finalize these numbers depending on enrollment. But for the propane certification class, which is 152 instructional hours, we would be looking at $3,650 as our estimate of what the cost would be to do that particular module. For the NORA Bronze Basic Oil Heat Technical Training Program, 80 instructional hours and $1,500 for that particular module. And for the air conditioning and refrigeration, $1,500 as well. And that would include the EPA 608 technical certification exam. So each of the modules would have a corresponding cost. One of the things we've heard from our employers is a lot of times they want to see if someone's going to stay and be successful before they then go on to doing an electrical apprenticeship program or a plumbing apprenticeship program, which is a much more significant time commitment, both from the employer and from the apprentice. We are looking at a 4-year program. The advantage of this and what we see as this pathway is that apprentices can come in, make a year-long commitment. The employer can make a year-long commitment. They're going to receive the training that they need and the certifications that they need to be doing this job within 12 months. And they can then expand and diversify their certifications and credentials by choosing to continue to stay on through a plumbing or electrical program. But at that point, they've seen whether or not they can be successful and whether or not they want to diversify their certifications. We know from our employers that there more and more need for people to have multiple levels of certification.
Thanks, Chair.
And do you have any connection with the technical colleges, the technical centers? In
We
other words,
do.
recruitment is a big problem. Do you ever have employers who say, I'd like to do this, but I'm having trouble recruiting? Do they look to you?
We do, and we often partner with our CTE programs and the technical education, and we can easily build this off of many of the relationships that we have. So we look at it as a dual pipeline, one coming straight from the employers and one coming out of technical education. But we want to make sure we're offering both for all students, recognizing that many of our students now are adult learners who are upskilling or changing professions and may not be coming out of a technical education program. So being able to pull from both pipelines, I think, will be critical to meeting the workforce need.
Great. Any other questions from members of the committee?
Yes. So I had a conversation with the General Contractors Association this morning, and they indicated, among other things, that publicity, outreach, recruiting is something that they could use help with. Do you sense that if there was more effort to recruit, that you would have more students?
Yes, and it's really exciting. So one of the projects that my team is working on, which is a little bit off topic, but I think is relevant to this conversation, is we're really doing a refresh of the brand related to workforce and continuing professional education. So we're working with a contractor right now to really identify how do we make this easy for our employers, for our students, for Vermonters looking to enter into this career path. So we'll be coming out with a really great new landing page and microsite that really builds upon this, but is focused both on the employer side and on the student side. And then additionally, we've been tailing that with our marketing efforts. So we're really trying to get that foundation up first, and then marketing through both earned media as well as some of our targeted marketing efforts, recognizing that there is a demand, but we need to be able to pull from different avenues.
Great. Anything else? Sarah, thank you so much. Appreciate your taking time. I think what you want to do here, it would really help me if you would do the following. We're kind of crammed here because we're beginning to get towards the end of what we call crossover. And so if you could get hold of what it was that Beth Manock, the chancellor, sent us, correct it. It's got two columns. One of them is for an IT program and one of them is for us, for HVAC. If you could just break out the HVAC, make sure it's right, and send it to me, and CC our legislative counsel, who is named is Cameron Wood, at ledge.state, et cetera. Okay, if you have any trouble, and CC me, if you have any trouble, let us know.
Will do.
Okay, thank you very much.
Thank you for the opportunity.
Sure, take care. We do have 23 minutes left, but I don't know if Matt Chapman is here. Magali, do you have any insight into this?
He's joining right now.
Great. What?
I found that.
Send it to her. Sarah, you don't have Sarah Truckle email?
I hope I do.
Morning, Matt. You want to get yourself more in the picture? The problem is at the bottom, maybe go to full screen, or someone can get him to full screen. Great.
Let's try that. There we go.
That's good. That's perfect.
All
Matt,
right.
thank you very much for coming. I'm going to have the committee introduce itself to you. And we have 25 minutes before the floor, a joint assembly. We're supposed to be there at 10:20. So I'm afraid your testimony is a little truncated, but that's life.
And that's fine. And I'm always happy to come back if there are further questions or we want to sort of dive deeper into various issues.
Committee want to quickly identify themselves to Matt?
Hi, Matt. Lovely to see you again. Ashley Bartley, Fairfax, Georgia.
Leonora Dodge, Essex Town, City of Essex Junction.
Joe Parsons, Groton, Topsom, and Newberry.
Okay, Tom Charlton, Athens, Chester, Grafton, and Wyndham.
Debbie Dolgan, representing St. Johnsbury, Concord, and Kirby.
Gail Pezzo, Chittenden 20, Colchester.
I am Elizabeth Burrows. I represent Windsor 1, which is Heartland, West Windsor, and Windsor.
And I'm Mark Montgomery, and I represent Calais, Plainfield, and Marshfield. And you must have changed your camera because it's really high resolution.
I did. I thought I was working off my computer camera when I intended to be on my other. So there we go.
So you want to identify yourself and take it away? I think we've got maybe 15 minutes.
You got it. So my name's Matt Chapman. I'm the director of the Waste Management and Prevention Division within the Department of Environmental Conservation. And Waste Management handles, amongst other things, the cleanup of contaminated sites and the redevelopment of contaminated properties program, or the brownfields program. I know that there's been some focus and conversation on brownfields. I'm happy to talk a little bit about like what brownfields are and the centrality and importance in some ways of brownfields to some of the work that we do. It's some of the most exciting and enjoyable work that we do within waste management to frankly help people clean up sort of historically contaminated sites in downtowns and in village centers. And I think, I certainly have heard some of the testimony and comments for improvement, but I think one thing I'd just like to put out there is I really don't think that anyone has questioned the way A&R staff work with the public and their availability. There are definitely process improvements that can be made, but I'm really proud of my staff and just want to put that out there as sort of a starting point of the work that they do here. So having said that, we have been sort of it's interesting when you enter into conversations like this. They really sort of raise some of the issues of concern that you didn't know existed. And I think
I'm going to interrupt you for 1 minute.
Oh, please do, yeah.
For the rest of the committee, Ashley and I were joined by Allison Clarkson in the Senate and Randy Brock, her vice chair, and met with, I guess it was you, Matt, and also the secretary of A&R. And there was someone else in the room.
The DEC commissioner.
Yeah, the DEC commissioner. Yeah. And basically asked, is there a way how can we really streamline the process and make it easier? And it was a good conversation, and Matt's here. Sorry to interrupt.
No, that's fine. And thank you for providing the committee context. I mean, so we came up with several ideas, and I think the committee has a copy of them. I'll focus on the funding first, since I think that's sort of the area that's sort of most centrally important. Several years ago, we were appropriated $2.5 million that was focused on brownfields assessment work and cleanup planning. That money has been difficult to use for a couple of reasons. One of which is we've been trying to spend down a lot of the federal money that we've gotten through the Bipartisan Infrastructure Act before we tap into more flexible state funding. But we've also encountered some challenges with just sort of state finance rules, and frankly, the time we most need this money is basically in the period during the construction season between June and August. And because it's one-time money and because of some of the financing issues, it being sort of a general fund appropriation sitting out there without being in a special fund has created some difficulties to access that funding during the most critical timeframes. So what we're asking with respect to the funding issue is take a previously appropriated one-time general fund appropriation and to transfer it to an existing special fund that is within within waste management that we can use on brownfield cleanup work, and then expand the uses for that money to include cleanup in addition to assessment. So I'll pause for just a second and ask if anyone has any questions with respect to that particular issue.
Matt, did you sent a bunch of us an email on February 18th?
I did.
Is that where that language is?
It is. Hold on, let me open.
Because I just want to, okay, yeah, I see it. Okay. So, but it's the whole thing. Is it all 3 or 4 of the things we discussed?
It is. So if you look at section 4, the last section of that is the appropriations language. So it's basically amending a previous appropriations act to transfer that money to an existing special fund.
Great.
Thanks. I have a question for you.
Yes.
This pool of money you're talking about that's set aside for assessments for cleanup, is that the same pool of money where RPCs get their funding for towns, or is it completely separate?
It's completely separate. So
Okay,
this is a separate set of money that exists within DEC. So then, sort of starting from the top of this document that was sent out, section 1. Another one of the issues that we've heard from the development community that is a challenge is what are defined as development soils. They're sort of soils typically in urban areas that have elevated levels of lead, arsenic, and something called PAHs, polyaromatic hydrocarbons. Both lead and PAHs often are from sort of legacy issues from automobile exhaust, from when we had leaded gasoline, and also from just sort of uncombusted carbon particles. That's basically what a PAH is. Both of them have adverse health impacts at, unfortunately, fairly low levels. That being said, most of those impacts occur due to dermal contact, right? Being exposed to those issues. So the agency worked internally to come up with an alternative to taking these soils and disposing of them, managing them at Coventry, at the state's only solid waste landfill. So the proposal is basically to have to basically allow, not getting into the language for a second, but just conceptually, it's basically to allow someone who has amount of soil that they need to remove to basically excavate that soil, and then there's another project that needs fill, or perhaps a land that needs to get graded out because it has a gully or something that needs to get filled in. You can do that as long as you meet certain conditions and get a permit to do it. So this is an easy permit, it's called an insignificant waste management event approval authorization. It's a permit that we issue out of our solid waste program, but it's a fairly streamlined permitting process, and it basically requires that these soils get generated from a contaminated site, so a site that's under ANR supervision, so we know what's in those soils, and that it's limited to these 3 contaminants that I spoke to, that they've been tested, and basically we can ensure that they're not leaching to groundwater above environmental standards. So in other words, the concentrations aren't so high that they're causing groundwater contamination. The third thing, yes.
And I'm going to interrupt you. The problem is, I think we're short on time just because we have to be in this joint, it's a joint assembly.
Sure.
And so we can't be, they'll whip us with a wet noodle if we're late for that.
Yeah.
But so I want to go I think of most interest to the committee would be the things we discussed where you would put a priority on housing. That's one. The second is that you would study and report back to us by November 1 ways to significantly shorten the brownfields process. And the third thing we discussed didn't require action by the legislature and had to do with the RPCs. So if you could talk to those two quickly, I think we've got about 5 minutes.
All right, I'll do them quickly then.
Okay, I'm sorry, I apologize.
That's perfectly fine. I understand. So the second one, the second issue the chair raised was basically it's being placed in statute. It's section 2 and what I proposed that basically says that when we receive a project in the brownfields program, that will prioritize housing projects over other projects. So it basically would we would take the housing project and put it at the top of the stack. The third issue the chair raised was the process improvement report. So again, it's section 3 in the language that you I think have, and it basically requires that the agency convene a group of stakeholders, basically people in the affordable housing community and the private housing community who deal in brownfields regularly, as well as environmental consultants, and identify where the areas are in the process that we that are a challenge or a pinch point in areas that we can basically improve in and decrease the amount of time. And some of that may be, I've had some conversations shared since we've last met, trying to figure out where some of the points are. Some of it may be figuring out like sort of alternative processes for low levels of contamination or common issues, so that we have more streamlined processes than our sort of more robust CAP process. So that may be one of the things that we come back with recommendations on next year. The other thing that is in the study is asking us to look at a licensed site professional program. This is a program where basically that's in place in Massachusetts and in other jurisdictions that basically transfers a lot of the review authority out of A&R and to the actual site professionals themselves. And then we audit the work they do as opposed to oversee particular sites. And then lastly, we have a historic practice of asking brownfields participants to go to the RPCs first before they come to A&R to ask for assessment or cleanup funding. We basically are going to repeal that historic practice and allow a developer to come to us first. In some instances, we can move a little quicker because there are multiple additional approvals that RPCs need to go through, and those approvals don't apply to the federal funding that we have from a brownfields perspective. So I think that covers the issues that we discussed, and I'm happy in the limited time we have to take any questions that folks have.
Any questions? We will revisit this issue, I'm sure, but the areas that seem to us to be most productive for legislation were their section 2 and section 3. One is the study that they would undertake by November 1st on how to really change their process to make it work better. And the second is just giving priority to housing. So that they said that could be significant. Of course, it means something else is pushed down, but short of giving them a lot more people, those are the two things that seemed most interesting. And Matt was happy to provide legislation language to us. I forwarded that to the council.
So we don't have those language yet.
I
didn't see.
It's going to go up on our website.
I'm posting it right now.
Okay, great.
Thank you.
And thank you very much, Matt. I really appreciate the limited time you gave us.
Well, like I said, I'm more than happy to come back if there's a need.
Okay, great. Thank you very much.
Right. Thank you.
Members of the committee, after lunch at 1 p.m., Cameron will come here and walk through additional language which will be in the meeting bill and some discussion. Thank you.
We can adjourn.
Yes, adjourned. Thank you.